Hi, everyone. Welcome to our webinar today. We'll give folks just a few seconds to jump on. And all right. So I have with me today Ryan Ferrante. So Ryan, we are going to jump right in. If you can just tell the folks here a little bit about yourself and your practice.
Of course. Thank you so much for having me, Hannah, Family Source Consultants. I've watched several of these myself, and I have personal and professional relationships with Dr. Trollis and Dr. Lindheim, who have been former guests. So it's an honor to be with you. I am a collaborative reproduction attorney or assisted reproductive technology attorney or any of the other names you might hear that are used to describe the type of work that I do. I'm a solo practitioner here in Chicago, where I'm licensed to practice, but I did not come to this practice of law by accident. I began my career as a boring old corporate tax attorney. Apologies to any tax attorneys that might be in the audience. It was while I was practicing tax law, beginning my career as an attorney, that my wife and I battled infertility ourselves for many years. We resolved that infertility with the help of the most wonderful surrogate in the world, who helped us have our family, and she is now forever part of our family. And so while we were overcoming the challenges of infertility, I sort of pivoted my career as a lawyer from tax to working with families like probably some in your audience, whether it be helping them in the form of egg donation or sperm donation or embryo donation, and most prominently gestational surrogacy. So I am independent of any agency or any other practice of law, and I work with intended parents and surrogates and donors, really all parties to those collaborative reproduction arrangements like surrogacy.
Perfect. Thank you. So the topic for today is obviously parentage orders. I know we will probably cover just some other legal things that come up as well,
Sure,
whatever we can
sure.
pick your brain about.
Sure.
But if you can start by jumping in to tell us a little bit about what parentage orders are, and then what purpose do they serve in general?
That's a great way to phrase that, Hannah, because I think to sort of understand parentage orders, that very specific part of the process, I have always found it easiest to understand the larger context of surrogacy and where it fits in, particularly in the legal processes. But before I paint that picture, I do want your audience to understand a few things. First of all, I'm going to try to limit the use of terms that may need to be defined. And then I'm also going to emphasize here that everything that we discuss should be discussed at length with your own counsel, because that's very important for your very specific circumstances to be understood before any advice can be given. Okay. A couple of other things that I just thought about, because every time I have these conversations, when we get to the end, I should have said something at the beginning. First of all, do not be overwhelmed about being named the legal parent of your own child born as a result of gestational surrogacy. Okay. Second, no two family building journeys are exactly the same, but there is a roadmap that almost all journeys can follow. And that roadmap is to complete all of the legal procedures required. Every intended parent in a surrogacy arrangement needs to have their own independent legal representation who's going to hold their hand through all these legal hoops that they're going to have to jump through. And they're going to be there to protect your interests as the parents of the child. Okay. So larger context I mentioned earlier. The picture I want to paint for you is that you first have to understand parentage orders in the larger context of surrogacy in the law. I always think about how the legal needs of intended parents and surrogacy arrangements can really be put into two buckets. I'm really about simplifying this in any ways that we can. Okay. So in the first bucket, we have a contract between the parties that defines the terms of the arrangement and the rights and the obligations of the parties, meaning the intended parents and the surrogate. Those are our parties, okay? This agreement is signed prior to any embryo transfer. At a very high level, this is your first bucket, your contract, all right? The second bucket is the establishment of the intended parents' legal parentage. Why do we need to do anything to establish your legal parentage? And what are we establishing? Okay. Here's where this may start to feel a little bit like a law school class, which I'm going to try to avoid for the rest of the conversation, but this is important. The law traditionally recognizes the legal mother of the child as the woman who delivers the child. Okay. And if she's married, the marital presumption of parentage would extend to that spouse. It assumes that the child born during that marriage are products of that marriage, and thus they're the legal parents of the child. That's the way the law views it. That's why we need to do something. Okay. That's why we need to establish legal parentage. So in surrogacy, we have to rebut those presumptions. Okay. Your lawyers are out there to rebut those presumptions in order to have you, the intended parents, adjudicated or determined to be the legal parents. Okay. That's the purpose of the parentage orders or other processes, which I'll get to in a second. They serve as the means of establishing the intended parents as the legal parents of the child, or to direct the hospital to put the intended parents' names on the birth certificate. In summary, parentage establishment is a necessary part of any surrogacy process, and the parentage order itself is the most common way to accomplish it. Or back to my analogy, to fill that second bucket. So that's really the primary purpose of the parentage order.
Very helpful to know. I think I would like to emphasize the do not be overwhelmed piece. So that is literally what you're hiring an attorney for, I think. So we're going to repeat that one over and over. So thank you. Can you talk to us then about where in the process does parentage orders fit in? When do intended parents need to start thinking about this, need to start talking to their attorney about this, need to start filing paperwork? How does that all work in the timeline?
That's a really great question. I'm going to give you an answer that you will often hear from a lawyer. Two very famous 2 words that every lawyer gets used to saying is, it depends. Okay. All right. So there is no specific moment, okay, other than consulting a lawyer about the path forward in a very particular state. I think to answer your question, it's probably very, very helpful for your audience if I talk quickly about how laws are applied in the United States. Again, I'm going to try and avoid any terms that need to be defined, but we have a system here in the United States. It's a system of federalism, which means that we have patchwork of laws all across the states, right? Every state is a little bit different about how they operate. Okay. And then to make this seemingly a little bit more complicated, the state law that governs your contract may be different than the state law that governs the process of establishing your parentage through a parentage order or otherwise. In that first bucket, remember, in the contract, in the first bucket where you're trying to fill up by having a contract that you have agreed to with your surrogate, that contract, the law that governs that contract between the parties could be the laws of the state where the intended parents reside, or where the surrogate resides, or where the embryo transfer is going to occur, or the state of delivery, if that state is different than the state where the surrogate resides, which, trust me, happens a lot. Okay. So in contrast to that sort of choice of law when it comes to governing your contract, the process of establishing your legal parentage, when you get to that second bucket, will be dependent upon the laws of the state where the surrogate delivers. Okay. That's the jurisdiction that's going to sort of govern the establishment of parentage process. Okay. But to your question, generally, filing for a pre-birth order in states where you can get a pre-birth order, or states where you have to wait until after the delivery in order to file post-birth. And even in those cases, we're still preparing or drafting the motions or petitions prior to the birth. All of that is usually going to begin sometime in the second trimester of pregnancy, okay? Because we want to get everything in order to be able to establish parentage before the birth or immediately after the birth. The timing of the filing of that complaint or petition will depend upon the state.
So speaking of things that are dependent on the state, are there other, it sounds like everything, your answer is
Yes.
probably going to be everything, but
Yes.
are there specific processes then that are state dependent that you kind of know as a general rule, just general steps in the process that might differ from state to state?
There may be. There are some things that are similar, some things that are completely different. But I don't think you could say, for example, that the processes in one state are exactly the same as they are in another state. There are certainly approaches that may look the same, but the filings, the timing of the filings, and the requirements for those filings, they're going to look different. If I were to say that there is one step that every intended parent will take to ensure a smooth and timely establishment of parentage, is to be sure that you've talked to a lawyer in the state where your surrogate will deliver before you sign a contract with your surrogate. It should happen before you sign the contract, but certainly before an embryo transfer occurs. You want to make sure that you have talked to a lawyer in that state that says, this is what we're going to do once we get to that second trimester to start the process of establishing your legal parentage.
That is very helpful. All right. So are there particular misconceptions that you've heard over the years that maybe intended parents have, or that the general public has, about parentage orders?
Yes. There's one very big one. And that's whether you are in a state where the attorney is can file a pre-birth order. So that's, you're going to hear these terms: pre-birth state, post-birth state. Whether you are in a pre-birth or post-birth state, there is some misconception that the outcome might be different. Okay. I want to go back to what I was saying earlier, about speaking to a lawyer at the early stages. You want to plan for the beginning at the end, or excuse me, plan for the end at the beginning. Okay. And so talk to a lawyer in the state where your child will be born, and you will find that the outcome is going to be the same, whether it's a pre-birth state or a post-birth state. The peace of mind of a pre-birth order is certainly not to be discounted, but the post-birth states will deliver the same outcome, as these types of orders or the hearings that come with them are generally a formality, because these are non-contested. Don't think about this like Law and Order. These are non-contested proceedings, right? Because the parties have already agreed as to who the legal parents of the child are. Okay. And so that's the biggest misconception, is that, oh my gosh, I need somebody in a pre-birth state. Not necessarily. Okay. Because the outcome is generally going to be the same.
It's very helpful. Do you, so for folks who have not yet found an attorney, would you recommend that it just be their one attorney the whole way through, who happens to be someone in the state where the surrogate will deliver? Or how does that logistically work then? Great
question. So not necessarily, because as I mentioned earlier about this federalism, this patchwork of laws, you may choose to have the laws of a particular state govern your contract. And this is obviously a decision that's only going to be made after you consult a lawyer in any state, right? And so whereas as an example, purely as a hypothetical, if a intended parents and a surrogate agree that they want to use Illinois law because it's very good law to govern the contract, you still have to have a sufficient nexus to the state of Illinois. You can't just say, oh, I want to use Illinois law, right? So it's got to be where the surrogate lives or where the intended parent lives. But then maybe the surrogate delivers in another state. Okay. I'll give you an example of a slightly complicated arrangement. Surrogate lives in Illinois, but she delivers in Missouri, right?
Mhm.
Because she's going to deliver maybe at a hospital in St. Louis because she just lives on the other side of the border. Generally, we would probably take a long look at applying Illinois law to the contract, while also making sure that they speak with an attorney in Missouri to understand what the process is going to look like when it comes to the establishment of parentage.
That makes sense. Yeah,
Yeah.
there probably some of those border issues are pretty
Yeah.
tricky
Yeah.
when you live near a state border.
Yeah.
All right.
Yeah.
For the folks watching, we do have the opportunity for you to ask questions as well. So I do have a couple more questions for Ryan, but please
Please.
feel free to put your questions in the Q&A and we will get to them as well. But to follow up then, are there other important things you want to make sure that intended parents know, specifically regarding parentage orders that we haven't discussed yet?
Sure. So one thing that I've thought about as I was answering the last question is, how do these orders, what is the really significant difference between states? I mentioned that I was a former intended parent myself. My children were born in Florida. Okay. And so my wife, Lindsay, and I had our own lawyer in Florida to address these issues for us when our children were born. The primary difference between states is that, and this is something that we've covered so on the surface level, is that some states allow for the filing pre-birth, where they will obtain a pre-birth order. In contrast, other states require that the attorney only file for the judgment of parentage after the birth. And we talked about how you shouldn't worry about the outcome being different in those two processes. And then some other states have a two-pronged approach, right? Where there's a filing pre-birth and post-birth notice of birth is filed with the court. I'll give you that one example here, which is my own personal experience. I'm sort of taking my lawyer hat off and talking to one intended parent to another here. Again, both of my children were born in Florida. We had our own lawyer in Florida, who was fantastic, by the way. And what she did is she filed a petition for parentage pre-birth and filed a notice of birth immediately after the birth. So quite literally, imagine this. I called her from the delivery room after each of my children were born to inform her and provide her with the name of the child. She requested a hearing as soon as possible. She filed the notice of birth, and a birth certificate was mailed back to us in Chicago within a few weeks. We also had a pre-birth order. So there's a combination of processes here. And I do want to emphasize one other thing, because I have a feeling we might get a question. I can't see the chat questions, but I have a feeling somebody might ask about this. Then there's my state, Illinois, where the process of having your names placed on the birth certificate is an administrative process without court intervention at all. Okay. So here, if you're considering the totality of circumstances of a particular gestational surrogacy arrangement in Illinois, and the parties have met certain statutory requirements, we just file certification statements with the delivery hospital and with the Illinois Department of Public Health prior to the delivery. So when the birth occurs, those two entities, Illinois Department of Public Health and the delivery hospital, they will communicate with each other to confirm that each has the required forms that an attorney like myself has filed timely. And then the birth certificate will be issued with the names of the intended parents. So Hannah, I do not want to, I want to clarify, after walking through those, distinctions between states, that again, this does not need to be complicated. It may sound like it in this abbreviated time frame, but when you talk to a lawyer, they are going to put in front of you that roadmap, and they're going to say, this is what we're going to accomplish, this is when we're going to accomplish, and how we're going to accomplish it, so that the parties understand that the outcome is going to be the same regardless of the process for establishing parentage.
Are there typically, do most states do it the way that Illinois does it, or Florida,
No.
or is it truly one-off every state?
Florida handles it. There's a handful of states that handle it like Florida handles it. Illinois is sort of an outlier when it comes to no court intervention necessary, as long as the totality of the circumstances is understood and they've met all the statutory requirements. They can do it that way. That's not to say that you can't get a judgment of parentage in the state of Illinois. You can. It's just that sometimes you don't have to.
That's fantastic. Okay. Well, we do have two wonderful questions from folks who are watching. So first question is, are parentage orders impossible to get in some states?
Parentage orders may be more difficult to obtain in some states, depending on, again, the circumstances of the case, because there, if there's for example, in the state of Florida, again, I'm going back to statutory requirements here. There's a requirement in Florida. I'm not saying that you can't do it if you're not married, but there is a requirement if you're going to use the statute, if you're going to request a judgment of parentage in the state of Florida, you have to be married. Again, I'm not licensed in the state of Florida, so don't take my word for that. Read the statute yourself or talk to a lawyer in Florida. That was always my understanding, is that it had to be a married couple, which obviously complicated issues for same-sex couples prior to the recognition of marriage equality, right? And so this is why understanding the complete circumstances of the case is important for you to have a conversation with a lawyer in that state that is going to establish your parentage. Great question.
That actually is a perfect segue into the next question, is specifically about does marital status matter, and does sexual orientation matter in obtaining pre-birth orders? And specifically, this person's asked about like the state of Oklahoma, but I would imagine that it would be applicable to any state where that may matter.
Yeah, again, not licensed in Oklahoma, but this is a good question. So marital status can matter. For example, when it comes to the filing of those certification statements, let's use Illinois as an example, actually. Filing of those certification statements is going to be done in any surrogacy case, regardless of marital status, so that you get your names on the birth certificate. There in Illinois, there's sort of a belt and suspenders approach that lawyers will always recommend if there is a case involving a same-sex couple who are the intended parents. Okay, why? Because of that federalism I talked about earlier. We have this patchwork of laws across the states, right? Now I promised I wouldn't get into terms that I needed to define, but there's something also to be, you may hear this when it comes to establishing your legal parentage in the state of Illinois, and it's called horizontal federalism, which means maybe your audience might be more comfortable or may be more familiar with the term full faith and credit, which is the Constitution of the United States says that judicial decisions must be honored in one state if they are issued in another state. So, for example, you get a judgment, a parentage judgment in the state of Illinois, the state of Alabama or the state of Texas or the state of California has to honor that decision. The birth certificate is merely an administrative document that, somebody in the state of Alabama, if there's ever a custody question or if there's a separation or divorce of the intended parents, they may want to sort of cement their parentage rights through a parentage order, judgment, or declaration of parentage in the state of Illinois, as an example. I hope I'm answering the question, but what I'm trying to say is that it is marital status. I'm actually going to just lean on that very famous lawyerly answer, which is it depends, right? It really does depend on the totality of the circumstances in your case. If you're married, I would still, in a same-sex, in a case involving intended parents who are a same-sex couple, they should be considering that belt and suspenders approach of certification statements and the order.
That
helps.
I think it's helpful. I hope we can get feedback from the group as well in the Q&A. So please chime in if you have other specific questions on that. are there any states then where there are restrictions for a single intended parent? I know you said that typically folks have to be married in some states under
Yeah.
some circumstances, but
Yeah.
would there be states where a single IP is just not accepted?
None that I'm aware of, but I meant just to clarify on the question about Florida, for example. If you're going to use a statute, if there's a marriage requirement, it says the commissioning couple must be married. It doesn't say anything about the commissioning individual. And so again, talk to a lawyer in that state who will interpret the statute for you and tell you whether there are any legal hurdles for establishing your parentage as a single parent. I'm unaware of any, particularly when it comes to Illinois. That those are the types of cases that I handle all the time.
Perfect. All right. So in this specific example that someone from the audience is giving, they live in Illinois, so their attorney is in Illinois. They're looking at a surrogate who's in Alabama, so different state. They've been given the advice then that they should speak with an attorney in Alabama, which is very similar to the advice that you'd given earlier. Would it make sense for them to use the same attorney that their surrogate is using in Alabama at that point, or should they seek someone different?
They should seek someone different.
Okay.
Listen, there's a I don't know if there's really two schools of thought on this, but in any surrogacy arrangement, when it comes to the two buckets, obviously this is the way that I visualize it, whether you're talking about the contract, filling that bucket to get to an agreement where the parties have signed the contract, or in establishing legal parentage, it is always my advice that the parties should have independent legal counsel during the completion of these two buckets. So yes, I would strongly encourage anyone to have a conversation with an Alabama attorney who are the intended parents, and then the surrogate to have her own independent legal advice in the parentage process in Alabama as well. That's going to be dependent on those conversations.
Very helpful. Thank you.
Yeah. I hope I'm not sounding like I'm punting on this, but I certainly want to make sure that your audience understands that I'm emphasizing again that there is this patchwork of laws, and so understanding a state's very specific laws are important, and you should talk to somebody who's licensed in that state.
Yeah, that absolutely makes sense. And we're getting positive feedback in the Q&A as well, so thank you.
Yeah.
Does every surrogacy journey require a pre-birth order?
No. Illinois, right? Well, I don't want to answer that. The answer is not necessarily, because in Illinois we file those certification statements. So if we have a very straightforward surrogacy where we're not concerned about the surrogate crossing state lines and delivering in another state, which, by the way, travel restrictions are addressed in great detail in that first bucket in the contract, where the surrogate is we're not sort of blocking her from living her life, but we certainly want to emphasize in the contract that it's very important that you deliver in the state, because we're going to start to take steps during that second trimester to establish parentage in the state of Illinois. For example, we're going to file those certification statements in the second trimester, and if you step out of the state and deliver in another state such as Missouri, guess what? No one in the state of Missouri, even at that delivery hospital, knows that you are not the legal parent to the child. So remember, I talked a little bit earlier about the presumption question. It's going to be presumed that she is carrying her own child, and that if she's married, the marital presumption of parentage will be extended to her spouse. So that's the purpose of those sort of travel restrictions that we put into the contract, to make sure that we're doing everything we can to set up the parties for a successful establishment of parentage in that second bucket.
Yes, I know on the surrogate side of the house, that's a frequently asked question about travel restrictions. So IPs, that might be a good thing to make sure that your surrogate is on the same page about.
Yeah, that's a thing. Like, surrogates, sometimes we'll push back on it, and they'll say, I want to be able to travel wherever I want. But they're all, here we go back to independent counsel. They're going to have their own lawyer telling them, this is the reason why Ferrante or some other lawyer is putting a travel restriction into the contract is because we want to make sure that all the work that we're doing to establish legal parentage is not going to be for naught, right? And so
Right.
that's something that is emphasized in the contract and plays out in the second bucket.
Absolutely. Okay, we have a few other. So, what would be, okay, so you mentioned that the surrogacy contract is an important prerequisite. Yes, we do love a contract. So
Yeah.
what would be your main recommendations and point of attention, things that should go into a contract in general?
Oh my gosh, I love this question. Just because, the parentage, laying out the roadmap for establishing legal parentage is just a tiny part of that contract. Wait until your audience, this is for your audience, wait until you see the contract. It's much longer than you'd probably imagine that it is. We are talking about any financial terms. We're talking about the parties' mutual understanding of a potential termination of pregnancy. We're talking about those travel restrictions. We're talking about insurance. We're talking about medical expenses. Who's paying for what and how and when? Is there an escrow agent involved? What law applies? So back to the real reason for this conversation, what law is going to govern this contract, and have we met the statutory requirements? I'll give you Illinois, for example. In Illinois, I mentioned that the marital requirement in Florida, but in Illinois, in order to be able to use the statute, the law was written in 2005, which is sort of ancient in terms of the technology that has come along with collaborative reproduction. But it's still really good law. There's just a couple of blind spots in it. One of them is that there has to be at least one genetic contributor to the embryo that's going to be transferred to the gestational surrogate. So in order to use the statute in Illinois, you can't use donor embryos, right? There's also a requirement that there is a medical need for gestational surrogacy. When we get to a final contract between the parties have agreed to the terms, it is sent out for signature to the parties, the intended parents and the surrogate, right? And we also send an affidavit to the treating reproductive endocrinologist. So your reproductive endocrinologist is going to sign an affidavit attesting that the parties have a medical, or the intended parents have a medical need to pursue gestational surrogacy, and that the embryo that's going to be transferred was created by combining at least one of the material from the intended parent. So whether it be the egg or the sperm, you can use an egg donor or a sperm donor, but using a donor embryo, you can't apply the statute. That's not to say you can't use a donor embryo and a surrogate, you just can't use the statute. It would be a different legal process for establishing legal parentage.
That makes perfect sense to me. Right, we are done with that one. Do you, can you speak to legal clearance letters prior to an embryo transfer? So, is there anything specific that the clinic should request on it?
Let me start by saying this. As much as a doctor doesn't want me practicing medicine, I would prefer that medical professionals who aren't lawyers aren't interpreting a contract and saying, no, you must do this, right? And so we do want to give them some information in the legal clearance letter. Once we get to a signed contract, the clinic does not get a copy of the contract. They just get that letter, that legal clearance letter that says the parties have signed an agreement. It's on file in my office. It is compliant with the laws of the state of Illinois. And then I usually give them two pieces of information. Okay. I tell them this is how long the contract is valid for, right? So it's a standard term is that the agreement is valid for 18 months from the time of the signing of the agreement, or, of course, as long as she's not pregnant, right? It'll expire at 18 months. The parties have agreed to up to 3 embryo transfers, which is also a standard term. Sometimes we'll say 4 embryo transfer attempts. The reason for that is, either party can terminate the contract at any time as long as she's not potentially pregnant, right? So from the time of an embryo transfer until she either delivers or there's some other end of pregnancy, or maybe she never even achieved a pregnancy, that's the window when neither party can terminate the contract, but either party can terminate outside that window. And so the parties will agree to up to 3 embryo transfer attempts within 18 months. And then also I let them know that the parties have agreed on the number of embryos to transfer. So whether we're talking about a single embryo transfer or double embryo transfer, the physician should know what the parties have agreed to when it comes to how much material are we transferring per attempt.
Perfect. All right, and we have one more question, and unless somebody else has something, well, we have Ryan here, so feel free to, again, we have a few more minutes if you wanted, but you have the opportunity here to put someone's mind at ease. So if a surrogate is a friend and they did not get a pre-birth order, is there a concern that if she delivers at a hospital she wasn't planning on delivering at, that maybe that assumption would be that that surrogate is the mother, and would put her name on the birth certificate? Like, would the hospital just put the surrogate's name on the birth certificate in that case because of the assumption?
It depends. It depends. It really does. It depends on the state where she's delivering. We'd have to look at state law to understand what needs to be done in order to, here I go again, rebut that presumption that she's the legal parent. How do you do it in the state where she's going to deliver? It's a really great question. I mean, if we're talking about Illinois, we should have those certification statements filed with the delivery hospital and with the Illinois Department of Public Health. And you really don't have that issue. But you should be, I guess my answer is if you have not done anything prior to the birth to either rebut the presumption or line up how you're going to rebut the presumption immediately after the birth by talking to a lawyer in that state, you really should be talking to a lawyer right away. That's my opinion. All right.
That opinion. That's helpful.
Yeah.
So talk to the attorney.
Yeah.
Always talk to the attorney. That's the
Yeah.
take-home message here.
Yeah.
Great. Well, I believe that wraps up the questions that we had. Are there other, again, items, advice, words of wisdom as either an attorney or an IP yourself that you'd like to share with the folks here watching?
Stay calm. There is a greater reward on the other side of this, I can promise you. And whether it's concern about the contract or the parentage process, let the lawyers hold your hand on that, because it's going to be I always tell intended parents, I want you focused on your relationship with your surrogate and about becoming parents. Let the lawyers do everything they can to make sure that you don't run into any issues when it comes to establishing your parentage. It can be sometimes difficult to place your faith in the hands of someone who's going to be taking care of all of that for you while you're focused on what's really important. But that's what I want my intended parents to feel when they are going through the process. Focus on the things that are really important. I mean, not to say that the legal processes aren't important, but you're going to need a lawyer anyway, so let them do their work.
Wonderful. Well, thank you. We'll leave our group with that. And thank you so much, Ryan, for your time and your wisdom.
Thanks so much for having me. Thank you.
Thank you.